today, and you are, as you probably know, you're charged with aggravated assault
Yes, sir.
causing serious bodily injury
Yes, sir.
after someone fell off the hood of your car
My son.
while you were driving the car, apparently. And apparently, your son who's, wow, gets worse every time you read it, huh? Your son, who is nonverbal and autistic, jumps on the hood of your car as you were driving away, fell off, you rolled over him,
Yes.
and he sustained serious bodily injuries. Where is he now?
He's a-
Where?
Mhm.
How are we doing that? She's not supposed to have any contact with any victims. You know that. That's surely she was told that.
Well,
I know this is no,
Judge.
wait till no,
Let the judge talk.
yeah. I mean, the rules are the rules. I mean, but we're going to not follow the rules. We're going to have some special orders in play. So the first bond rule is don't have any contact with the victim. I know this is the son, but she is the defendant of the son being seriously injured, who she drives over her son. And we got some problems here. Why hadn't that been addressed?
Judge, I'm
Until
not
today.
sure why that hadn't been addressed. This is an unusual situation.
I know.
It's actually her home. She lives there with some other family members, not just she and the.
I know, but we got to work this thing out. This is a half a year old.
Can I speak?
No, not right in a minute.
Not now.
In a minute, because you've been violating a bond condition since you can't have any contact with the victim. And you've been living with the victim. Now, I've got to approve that. The first condition about, you're on a bond, right? Yeah, how much is your bond? It's what, $8,000?
Mhm.
Your bond can be revoked right this moment, and I could say, you're gonna sit in jail until we get this resolved, because the first thing you violated was have no contact with the victim. This is a special instance, but I'm sorry, we work these things out, but all too often when we have people who live in the house, we allow them, the next thing you know, they have manipulated the whole system. They have manipulated. We're not in control, they are. But the people who are spending the money on the costs of the judicial system expect the rules to be followed. And they're going to be followed on my watch.
Judge, I've reviewed the paper discovery and.
No, I don't want to talk about the bond
Well,
first. What's the
yes, sir.
bond?
I just
Okay.
want to tell you what my background on this is. I don't know as much information as I need to know. This is the first time I've met this lady. It's my understanding that there's really nowhere else for the victim to live except in her home, which is her house. But I can find out about this today, Judge. I just have not been able to do so. It's
Are
an
you
unusual
retained on this?
situation.
Are you retained?
No, sir. I'm appointed.
Okay. When did you get appointed?
The first I show on here is
What does that show?
12/4/2024. I don't know when I was appointed, but that's the first resetting I have received.
I want to know when the appointment was made.
Well,
Let me see.
I imagine it was when she was arrested, but I don't think.
Half a year ago, and nobody's met?
Yeah.
Yes.
CPA.
That's disturbing.
No, unless the judge asks you a question. Judge, I don't have any notice that I was appointed.
May 9th.
May 9th. You were appointed May 9th.
Yes, sir.
How did that happen? How did you not get any notice of that. I mean, the system is not working on my watch. That makes me look bad now. How does that happen? I mean, that's 7 months and nobody's talked at all. And meanwhile, the bond condition has been violated for 7 months. I mean,
I'm
this
sure
is like a
His
Three
appointment,
Stooges movie.
his appointment occurred whenever she was initially arrested on these charges, Judge.
So what?
No, I'm just stating that's
It's-
the significance of the date.
And at that time, Judge, she had not been indicted on anything.
She got indicted in June.
Yes, sir, but at the time I was appointed, if it was in May, was not when she got indicted.
But nothing, y'all haven't talked in 7 months. And meanwhile, here we are, a bond condition is being violated that needs to get worked out.
But can I?
I'm talking to him right now because we got a problem.
Okay.
This is a cluster mess. This isn't the way things are supposed to work at all.
Judge, I think if it was anybody's fault, though, it wasn't her fault. I think it's
She,
something.
no, so they went over the bond conditions with her, or else the bondsman's at fault. And if the bondsman at fault, I'm going to deal with that. I mean, we can't be coming up, I didn't know what the bond conditions were. That's not an excuse. That can't work. We got between the lawyer appointed and the bondsman dealt with, two people should have been telling her about it. Plus the magistrate, I think, has somewhat of a duty that you're going to, if you make the bond, here are the bond conditions. But she gets a copy of them. I think the bondsman gives them a copy of what our normal conditions are.
No, bail bonds, I think we've discussed with them before what their kind of business practices. I do think that they have them initial the bond conditions. I can
Yeah.
call and see.
Yeah, if they
that's over.
if she initialed the bond conditions, shame on her. That meant she was told about it and she was aware of it and she had to meet it or else. They got any bond?
I can see if we can call and see if they can fax over their paperwork.
No, I can,
Judge,
the rules are the rules are the rules, period. This is disturbing.
there, in addition to this, because it involved involved her child, CPS was involved in it. Beaumont Police continued to be involved in this. They've been involved in it
Yes.
since, I guess, since May, whenever she was arrested.
Yeah.
All right, we bogged down. We're gonna take it up at the end of this docket, okay? Everybody,
Yes, sir.
thank you. Because this is way out of whack. You're gonna follow the rules like everybody else is required to. You're gonna be held accountable. Just wait. Let me go to Dante Mahone and see what happens with Dante Mahone.
Judge, I'd ask to have her case reset if I could for a minute.
Have a seat right up there. Thank you. Dante Mahone, please. What do you want to do on this?
Well, I'd like to have, I'd just like to have some time to investigate the case.
Okay,
Uh,
but here's the standard bond condition she signed back in May. Defendant shall not communicate either directly or indirectly with the alleged complainant victim of the pending case, nor shall the defendant go near any residence, school, job site, or other location frequented by the alleged complainant victim.
as a result of this, Judge, Child Protective Services was called to the site, I believe, by the Beaumont Police Department.
Mhm.
They investigated the child before he was, when I say child, he's an adult, but it is her child. Before he was taken to the hospital and investigated where he was going to go after he was released from the hospital, which was back to her residence, and approved it. And I don't think that she understood that was a condition of the bond. In fact, asked the bonding company about that, and they were aware that that's where. Anyway, I think the reason that it is a violation was it was just very inartfully occurred just based on the facts of the case.
What does that mean?
Well, that means I don't think anybody thought about that until after everything had been done. The child had been taken to the hospital, and we are going to have to make some arrangement if we can't stay there too, which I understand the courts, that's the court's order.
Oh, in every case, yeah. Can you imagine something bad happening next?
Yeah.
And when I ask you a question, I'll direct it to, I'm talking to
Just
you.
be quiet, Mr. Judge.
I mean, can anybody think of a worse scenario than something bad happening here in this, to this, the victim that was perpetrated by the defendant at this state of this case with the orders that are in effect? Who would be to blame then?
Judge, I don't know who would be to blame, and unfortunately, I believe though, because Miss Goley, as well as the Beaumont Police Department officers that were there, the Child Protective Services officers were there, the EMS, everybody approved the child going back there without thinking about this being a violation of the court's order. And I realize that's not an excuse why somebody can violate.
Yeah, I would like to know really how that I'd like a hearing on that, because we're going to have a hearing and I want everybody involved who thought that was the right thing to do before I ask for it. Because the grand jury indicted this and they had information. We see the indictment here, but for people to get together and contradict a court's order without telling a court is about as bad as it gets. What's the state say? Y'all looked into
Well,
it.
Judge, the one thing I want to weigh in that you haven't heard is that apparently that location is not this lady's house. It is her mother's house. It is certainly a good place for the child victim to be at. He is a 17-year-old now, but there's certainly no reason for him to leave, but there's every reason in the world for her not to be there. And I don't believe that the police department or Child Protective Services have authorized her to be there in violation of your court order.
Yeah, we're going to have a hearing on that. Everybody get ready. I want this in next week, please. I want a hearing on this.
Yes, sir.
But you're going to jail.
Why? No.
And you're going to go to jail because this is terrible. I can't.
Yeah.
And you like to interrupt everybody, don't you? Yeah, that's what you do. We learned that in kindergarten not to do that. The and I'm just not being hysterical here. Reading this indictment, it says you intentionally, knowingly, or recklessly cause serious bodily injury to Braylon Sevowitz, which is your son. Is that correct? Yeah. By driving you were driving a motor vehicle while he was on the hood. Then you drove over him after he fell off the hood, and you used or exhibited a deadly weapon, namely a motor vehicle that in the manner of its use and intended use was capable of causing serious bodily injury or death. And that's what the grand jury indicted you. Hold on. According to the probable cause affidavit, you told the police your son jumped on the hood of your vehicle and that you began to drive away with him still on the hood. At some point, while driving on Gill toward your residence, your son jumped off the hood and she ran completely over him, causing him to go underneath the entire length of her vehicle, which caused him to sustain serious bodily injuries. Due to the fact that that the defendant, states in the probable cause, were reckless in driving a motor vehicle with her nonverbal autistic son on the hood of the vehicle, which resulted in a serious bodily injury to the child, she was arrested for the charge. Okay. And the grand jury reviewed it and then decided that's the way it should be. But this is one of these situations where I can understand, we've got an autistic child. The mother is charged with a crime. This has to be dealt with delicately and deliberately. But the rules, the standard bond conditions were put in place for good reasons. And here's the deal. I'm just finding out right now that that's been violated for months. Well, I don't like it. I don't like it. But
Yes, sir.
now everybody knows about it. The defense condition is everybody knows about it. Well, we're gonna have a hearing next week on this, and I want everybody involved who's part of this, who has been aware that bond conditions were being violated, and nobody took an affirmative duty to do the right thing, and that is alert the court so that the courts can bond conditions have effect rather than or being blatantly dis blatantly not followed. And otherwise, a court's order is meaningless, and it's going to have meaning to it. And the court always is subject to change on its orders based upon change conditions. But I'm sensitive because far too often we have cases where the defendant is familiar with the victim because they're related or associated some way, and they have violated the conditions by contacting or communicating or becoming. I hear another word from you without me asking you. I'm listening to you grunt now.
I'm not. I promise to God.
Okay, be quiet.
Quiet, be quiet.
Okay. Wow. Wait, I'm scolding you like a kindergarten teacher scolding a child. My goodness, over and over. But everybody knows what the rules are, and nobody, not everybody, but folks are aware of the rules and then did not alert, which everyone has an affirmative duty to alert the court about a violation, or someone or others are going to be held. This because the worst thing can happen is something bad happens, and then who let everybody get together until this got resolved? Who? Me. And nobody's telling me. I'm the one in harm's way now, and I don't think that's fair for any judge. Thousands of cases I'm trying to rectify, but I'm making a big deal about it because it is a big deal. Because the worst thing can happen in a situation like this, and then everybody gets held accountable, which it ought to be. But I'm in the line of accountability, and nobody told me about what the facts were. And that's not right. So we're going to have a hearing to find out who knew and why the court wasn't made aware a half a year ago. This is crazy. This is craziness. But you can't have any contact, and you've known it. And bondsman, you signed it. And this is going to be made a part of the record here. And but you're going to jail. You knew better, and dadgummit, it's just not right. I am next. What's the bond condition? What's her bond amount? Okay, it's double to 16,000, and you must have a GPS device so I know where you are. But the next time I find contact or a violation of a bond condition, the court's not going to release you, give you an opportunity to be released at all, man. This is, first of all, this is a serious case in the first place. A child was seriously injured, driven over by the mother. Now, and we got to figure out how that all happened and what the circumstances were. But the rules are in place, and that means no contact, even when it's a mother and a child. Sorry, but the grand jury indicted you for this. The probable cause affidavit sets forth clearly a situation that's very disturbing. But we've got to resolve this. If it's going to be a trial, let's get to trial. Then it can't be a real long one. We can move this thing up as soon as possible. But the rules are going to be followed.
Yes,
Period.
sir. And,
Okay.
and
That's
again, I don't think that anyone
But we'll hear about it. I'm going to
knowingly
reset it.
violated or intentionally violated the court's rules.
No,
I
no.
don't think
Yeah, I don't
anyone
care.
thought about it under the circumstances. I'm not sure that the
whether it's
CPS
intentional,
or my PD knew that was a condition.
whether it's intentionally or knowingly, I want to know. If they knew about it, it doesn't have to be intentional. They got a determined duty to do something. If they knew about it, come on. But and how
Gentlemen,
many?
Can we have that marked as a court's exhibit? Because I believe it's got her signature and the conditions that Your Honor has
You're
referred
talking
to.
about the standard bond conditions
Yes, sir.
that the defendant purportedly signed, along with the
Because
bonding
ultimately,
company on
Yes, sir.
May 9th of 2024.
so the reason why the state wants that is ultimately if it's going to become a swearing match, I certainly want the court's record to be clear that she signed off on that and she would have knowingly not followed those conditions. Thank you, Judge.
Thank you. This isn't even close. This is serious. This is very serious. This is even close to being, this could go either way. This is disturbing. Puts everybody involved in the loop here in harm's way. That's the way it happens too often here in this courtroom. People decide the rules aren't going to be the rules and they're going to do their own rule following. Not that they spoke to one. All right. Period. All right, court's exhibit number 1 in this cause number 24 CR 1314, which is a copy of the standard bond conditions that purportedly the defendant signed on May 9th, 2024, which includes number 3. Defendant shall not communicate either directly or indirectly with the alleged complainant victim, nor shall the defendant go near any residence, school, job site, or other location frequented by the alleged complainant victim. She's been living with the victim. And nobody let this court know until voila today.
Thank you,
That's part of the record. And in this case, for all purposes, you were in custody. And
Judge, in addition, her father is in intensive care in Galveston County right now. She was planning on leaving to go see him. He's in.
well, where's the complainant going to go? That's got to be resolved.
With my grandmother.
I think she's going to have to.
I did not know with my grandmother.
I'm sorry.
I
You
talked
kind of
to-
swore to God on this.
Talk to the bail bond company.
That's all. That's all. That's all. You were taken into custody. The court's orders are what they are, man. Here, this is made a part of the record for that case.